So we have half an hour for questions, but please make them very brief, and because I'm sure there are many people who like to ask questions. Yes, please.
Hello, my name is Sabine McNeil, and I publish a website called Victims Unite. And I'm here because on Monday, a 4-week criminal trial is going to start for a Nigerian family whose 7 children have been taken by Haringey Council. And I'm desperately looking for help. It's clear to me that the ICC does not seem to be the appropriate court. And I just wonder whether maybe the Truth Commission might be a way out of this absolute abominable situation of secret family courts in this country, where apparently only Parliament could possibly remove judges as a way out, and this absolute incredible power of Haringey police interfering, no rights respected in prison at all, so that on the website that I've published, people are talking about bloodline genocide. And I really, really have only come to this event hoping that there are some other voices who are filled with a sense of outrage to what's happening against Africans in this country, which dares and thinks that the system of justice needs to be exported as a plan of growth. I've got all of those links on the website, but the integrity of the courts in this country is what is at stake in my view, and I would love to see if there is a chance how you can redress that. The UK is absolutely unique in the secrecy of family courts and in gagging orders. And the stories that I have published and come across on Victims Unite and the other site called gloriamusa.wordpress.com are just so horrendous that it is in a way difficult for me to bear it. So thank you for having listened.
Do you want to take? I'll just take questions again, then you can come back. Any more questions?
Yes, please. My name is Sam Acha. I'm from the Democratic Institutions for Poverty Reduction in Africa. We work to promote independent institutions without political interference. My question is to Mr. Dixon. You made a very, very interesting presentation, but I wish you had time to talk about the Sudan. However, you said enough to make me raise this question. How do you think the ICC will be able to be critical in the examination of cases as long as they appear to be getting instructions from the Security Council? You mentioned the fact that they only follow cases which are popular to the international community, meaning Britain, the United States, and France. And how do you think all these failures is due to the individual styles of the chief prosecutors, such as Mr. Ocampo, who appear to have been prosecuting, doing a megaphone prosecution, selecting his victims on ICC, on the How do you think that this will change now that we have a new prosecutor in the person of Mrs. Fatou Ben Souda?
Any more questions? Yes, please.
Jonathan Barra, Africa Research Institute. My question was to Tim, to ask him if he could finish off what he was going to say.
Yes, back there. Oh, I thought it was somebody back there. Okay. Go ahead.
Thank you very much for that. Just a very quick question from an interested observer. You've focused on the fact that a lot of the cases aren't being brought back to the countries where they might be tried locally. And I wondered if you could perhaps talk specifically about the impact of the Kenya case, in the fact that the courts there, while some might say are not equivalent to the robustness of, say, for instance, courts here, they are undoubtedly some of the best in Africa and surely should be allowed to try the case at home. And I'd also wonder if you might comment briefly on the issue of complementarity, which I understand the ICC has, under the Rome Statute, an obligation to include in its work, yet in the last 9 years, it seems entirely, as you've suggested, Mr. Clark, particularly been about taking cases out, in this case of Africa, and not assisting the development of local courts and the capacity there.
You want to respond to the panelists? The specific questions addressed to you? Okay.
I'll start on the question about the Security Council and related matters. The point that I was trying to make is exactly that the ICC needs to draw on its inherent powers to be prepared to review what the Security Council has referred to it. So in the case of Sudan, if there is a challenge about whether or not it is in the interests of justice and peace for cases against Sudanese leaders to be brought, then that should be heard by the court. If there's a challenge on the sufficiency of evidence, even though that government doesn't recognize the court, there's no reason why the court can't look at that. It's absolutely critical that the evidence underpinning these allegations is reviewed by the courts. They can't just go on the say-so of one side, the prosecutor, because we know that those warrants are out there and they have huge effects on the country concerned and the surrounding area. So the court should see it as its responsibility to try and make the right decision as soon as possible. Don't leave it to when somebody might ever be arrested or confirmation proceedings. There are ways in which it can be done now. And there's nothing preventing the court from doing that, to try and establish its legitimacy, to say, look, we're not just going to sit here on our hands when we know there's criticism out there. We'll hear the challenges. We'll look into it. And we're not afraid to do that. We'll open it up and deal with it. So that's exactly the approach which I'm saying the court should be adopting in respect of many of these situations. Yes, it's true that a lot of that might be driven by the assessment one makes of the prosecutor, because the prosecutor could also play a very important role as an independent and fair prosecutor and say, look, I'm not here to grind the axe against one or other country. I'm here to see that justice is done. So I want to encourage the court to do this. I'm not afraid. I'll show you all my evidence. It seems that in many cases exactly the opposite is true. There's a sort of hiding away of evidence, when usually if you've got strong evidence as a prosecutor, you want to make it known, because then you're in the clear. No one can criticize you in the press or wherever anymore. So he could facilitate it, but it also requires strong judges. And judges who are prepared to be independent of any political considerations. As regard to the next prosecutor that's coming in, I mean, I understand that she is Africa's choice in some ways. So there will be, I think, some pressure there to try and ensure. This is what I hear. Maybe there can be other views expressed. But she has been the deputy of the existing prosecutor, so that has to be taken into account. All I'm saying is that I think there might be some expectation. And although I can't predict what's going to happen, I would encourage her to try and take on some of these very important issues as the new prosecutor and open up a new page, reassess some of the cases that she's got, see whether any of them should be kept on the books or whether it shouldn't be more important to look at new cases, ensure that there is a real and genuine effort made to look at cases outside of Africa. We've had the Colombia case on the books for over 8 years, with endless people saying nothing's being done there. The crimes are just being left. They're not being prosecuted. Now, there comes a point where you can't just keep saying, oh, well, they're doing something. Russia, Georgia, exactly the same. And I mean, that's a very sensitive question because it involves Russia. But the longer that sits there and nothing's done, the worse it begins to look. Either deal with it and do something, or otherwise give explanations. It can be done through the court process as to why you're not doing something. I mean, sometimes you can't bring a prosecution. You simply can't. In this country, very often the CPS says, look, we can't do this. It's not in the public interest to do this. Well, then the prosecutor should say that as well. I can't do X, Y, and Z, and these are the considerations. I've got the investigation done, but my hands are tied. We'll try and see what I can do at a later stage.
Yeah, I think there was a specific question. Tim, did you?
I really liked my question, which I thought was really insightful and was basically asking me to talk more. But do I get another 6 minutes? It relates to the last question as well on complementarity, because, and of course, the way in which debates around traditional justice have been brought into the frame here is around this issue of complementarity. Not necessarily in the strict legal sense, but with lobbyists saying, well, if you're going to talk about justice in a serious way, linking it to the interests of victims, you have to think of what they perceive as being complementary. And what I was going to say, and I will now say it now, is that there are, I think, a number of characteristics in the way in which transitional justice has been packaged, which are worth just highlighting very quickly. One is that the emphasis on traditional justice that we've seen in recent years is part of an increased focus on non-state forms of governance in different parts of the world. It's part and parcel of that. We see it in the World Bank World Development Report on conflict, the emphasis on looking for alternative forms of governance that might exist in different parts of the world. So we need to see it in that context. Secondly, it's, if you like, a concessionary development within transitional justice thinking, that a recognition that whether it's truth commissions or international criminal prosecutions, they have limitations in their meaning to the peoples that are at the receiving end. So if you like, it's a concessionary development within that way of thinking. Thirdly, it's pragmatic, it's cheap, it's there. You can do something. It's a little bit like the arguments about traditional healthcare or local healthcare. There are people out there doing things like traditional birth attendants. Let's use those. It's easy to do it. Next, fourthly, yes, it's idealistic. And one of the points I often hear from people is that it's better. Particularly, I hear this from many Africans, not all, but many, who will sometimes say, you know, do you think justice comes from the briefcase of the white man? Which was a phrase used in a debate I had with one of my African friends. You know, that African justice is better. And there are many people writing it from an international perspective who seem to have taken that on board, I think rather naively. The last point I'd make is that there's no clear definition of what we're talking about. What is traditional justice? It varies hugely from one place to another. I'm going to just list what seem to me to be the really big controversies, some of which have arisen partly as a consequence of the International Criminal Courts and its involvement. One is, with traditional justice, does state capture matter? When there's an attempt to institutionalize traditional justice, to codify it, there's always going to be then a tendency to make it in some way hybrid. It changes it. It's linked to outside influences. I mean, the most obvious case here is the Acha system in Rwanda, which of course Phil has written about very insightfully. It varies hugely from place to place. Does that matter? It changes it. It's no longer really a local judicial system. As soon as it's codified, as soon as there's an external engagement, it's turned into something else, which may be useful, maybe not, but it's not actually local justice anymore. The second point is it restorative? Is it actually different to international justice? I think the answer there is it depends. The idea that there is no punishment in traditional justice is complete nonsense. You know, in some of the places in which I have worked, if somebody's accused of witchcraft and is, in a sense, if you like, there's a consensus about it, that person is killed, some cases brutally, in really horrific circumstances. The idea that traditional justice has no dark side is complete nonsense. So if there's going to be an engagement with local forms of justice, there has to be very careful monitoring of what's going on. The next point is, does it matter when it's invented? Because often it is. Once you start getting external interest in local procedures, there is that tendency to look for certain sorts of things that replicate international values and then promote them. Obvious case here is in northern Uganda, where one particular ritual associated with one Acholi clan that was involved, you know, to do with a compensation ceremony in terms of conflicts between clans, was picked upon by the international community, lobbyists, NGO groups, Matuaput it's called, drinking of the bitter root, and turned into some kind of healing system of justice that could actually be an alternative to the International Criminal Court. It was actually incorporated into the peace negotiations with the Lord's Resistance Army. Does it matter that that local ritual was then given that meaning which it's never had? It turns it into something quite different to what it was, but we have to be very clear about what's going on. And the final point, I just wanted to come back to this issue of the dark side of traditional justice. Something that's really alarmed me in my more recent research in areas where there have been local debates about the International Criminal Court's involvement, the need for local judicial processes, is that dark side has also taken on a new agenda. So across northern Uganda now, in parts of southern Sudan, we're getting the institutionalization of witch cleansing rituals, where local councils, for example, are involved in witch trials, and where people who are found guilty are then punished in public, with pictures of witches being put up on trees. And this is then being linked to this idea that there is a kind of a complementarity procedure with respect to the International Criminal Court's involvement. So, the point I would want to make about it is, if we're going down this route, be really careful about what you wish for and to watch very carefully what's going on, because all sorts of judicial processes are linked to hierarchies, often gendered hierarchies, and at the local level that can take on very nasty consequences very quickly.
Was there any more?
Is that the right answer?
Yeah, there was a brief one at the back. It was this question about Kenya and complementarity. I mean, I'll be brief on this. I'm not a specialist on the Kenyan court, so I couldn't talk details there. But I think there's a general question here, which is, what is the role of the ICC in the face of enormous amounts of judicial reform happening right across Africa? And I think the big question is here, and it's largely a question directed toward donors, is in terms of long-term investment, is it better to be pouring hundreds of millions of pounds or euros into international justice when it might make better sense to put that amount of money into domestic institutions? A good example of this would be what's happened, not just in Ituri, as I've already talked about, but also the Rwandan domestic judiciary, which has gone through substantial reform in the last 6 or 7 years, to such an extent now that the UN War Crimes Tribunal is transferring its cases to Kigali for prosecution. My sense is that that's a very welcome development, but it should have happened about 6 or 7 years ago. The impact that it has on a domestic population to actually have these trials happening in their midst, where people can watch them and talk about them in a much more intimate way than they can when they're in distanced institutions, I really can't be stated enough. But there's a kind of arrogance about international justice that it's inherently of a higher standard than what we're seeing in domestic courts. My question is here, that do the early years of the ICC actually prove that to be the case? Now, we can say, okay, it's a young institution and it's developing, et cetera, but in fact, the early signs of the ICC is that actually we're getting a very poor standard of justice come out of this institution. And we need to hold it to account. In the case of Lubanga, as I've already said, that case probably should have been dismissed. The evidence was that weak. My sense is actually prior to that, as I've already argued, that case should never have come to the ICC in the first case. In terms of its legal rules on complementarity and admissibility, my strong sense is that those cases should have been done in the Ituri courts. And in actual fact, that was also a mistake made by defence counsel, who should have pushed that argument much more strongly, and they failed on that front. But on its own rules, on its own terms, the ICC is not meeting those standards at the moment. And this question of domestic judiciaries is crucial, because ultimately those are the institutions that are going to continue doing this work into the future. The ICC will come in and do a small handful of cases at best, 2, 3, 4, 5 cases, and then it will move on. Had it not been for Kony 2012, the ICC really had written the Ugandan case off. The ICC had made all this fanfare about Uganda when it was very sexy during the Juba peace talks, 4 or 5 years ago. But when it became clear that nobody could arrest Kony and the hierarchy of the LRA, the Office of the Prosecutor in The Hague shifted all of their staff and financial resources that they had allocated to the Uganda case to a range of other cases. So it's only public pressure and a very peculiar internet campaign that suddenly now has the prosecutor out in the open making public statements about that case. But they had moved on. And the ICC will continue to move on from cases, but leaving domestic judiciaries to do the bulk of the work. Now, when the prosecutor first began his work post-2002, not only the word complementarity was very popular, but also positive complementarity was something that OTP was forever putting policy papers out. We're not just interested in complementarity and admissibility, but we're interested in this idea of positive complementarity, which was that the court could also help bolster the capacity of domestic bodies so that they would be left in a better state when the ICC moved on. But that's a very unpopular term now within the Office of the Prosecutor. No one wants to talk about positive complementarity. My sense is they were never that serious about it at the outset, that this was a very good marketing tool, in essence, to say, well, we do care about helping domestic judiciaries. They don't. It's a new institution. The ICC needs to get runs on the board. It wants results. It cares about its own output and its own work. And I think its sense is, if it can do its work and get out of certain African countries as quickly as it can, then it will.
Right. 2 more questions. I think we don't have much time. So I see one here, and I see the lady here. Please, very brief. We're running out of time.
Yeah, very briefly, that the ICC has actually proved to be irrelevant as far as Sudan is concerned. The history tells that during colonial administration, there were about 30 conflicts in Darfur, which the colonial administration managed through traditional justice, meaning reconciliation between these tribes, because they can't carry their suitcases and move to another country or another part of the country. These are thousands and thousands of people. So what the Sudanese government was saying, that it's not about punishment, it's about reconciliation between these tribes, the way which the colonial administration did quite rightly, exchanging kidnapped women and children, and the chiefs embracing each other in the end, and then deciding not to encroach on each other's territory again, because they are going to live in this part. Whereas the ICC's recipe was they wanted to take the president to The Hague, stop reconciliation between the two tribes, which is now taking place actually. Britain and America helped the 14th of July agreement in Doha, which has brought about reconciliation, and now it's underway, and the president is still in the palace. So the ICC has become irrelevant and completely impotent. Thank you very much.
Yes, please.
Hi, thank you. My name is Liz Evans, and I'm with Human Rights Watch. And I just wanted to push back on the idea that there's a tension between investing in the international system and local courts, local criminal justice mechanisms in any event. I completely agree with you, Phil, when you say that the court has to be attentive to its case law. It has to make sure that it's articulating a complementarity principle that doesn't undo the whole idea, that it doesn't set such high standards and is not receptive to arguments being made about the genuineness of the ability and the willingness of national governments to prosecute. But at the same time, I wonder if you don't see, as you know, over the last 9 years, a relationship between where the ICC is acting and generating the political will that's necessary to have prosecutions, say in Eastern Congo or in Kenya, because even what donors may be good at, building prisons, training judges, and what the judges already there may themselves want to do, is often in tension with the political will of the government itself in Kinshasa or in Nairobi to let them get on with the job. So I'm wondering if what is demoralizing here, is it really how the ICC is acting, or is it how national authorities are acting? And that in fact, perhaps why you have some prosecutions in Eastern Congo is because the ICC has managed to keep some spotlight on the issue of accountability. I don't want to overstate it. I mean, it's a genuine question whether you see that relationship. But thinking right now of the case of Bosco Ntaganda, would there be such an interest in his arrest were it not for the ICC warrant? Would there be commitments now from Kabila to arrest him were it not for the fact of that warrant? And the same thing in Kenya. The government really only seems to talk about having a local process for local prosecutions when the heat is on at the ICC, when there's announcement of the next step in the trials. And so isn't there a way of capturing that in a positive way, of that political will, that attention to accountability, which might actually catalyze conditions nationally that are necessary to support these trials, and then we would have what I think we all aspire to, which is justice first at the national level, where blocked at the international level, and then hopefully additional cases brought again at the national level once those conditions have changed.
Yeah, these are very broad questions. I think, can any members of the panel, one each, 1 minute each? You can say everything you wanted to say, but we're afraid to say in first person.
Thank
in
you.
1 minute.
I would say that I'm really happy that the last comment has come out, because I think by default rather than by design, this has ended up being a totally ICC bashing session, which is not totally helpful. I can say for certain that in the Kenya case, had there not been discourse around the ICC, it would not have triggered the process that is now there. And I'll just say to you, Phil, when the Kenyan government says that we would like to bring about an admissibility challenge, and at some points they call it an admissibility challenge, at some point they go for an Article 16 deferral. Are they saying that we are ready now we have done investigations involving these very individuals and we're ready to try them? Or are they just saying, look here, we just have a new constitution and you know, theoretically, with a new constitution and a new court and a new system, eventually at some stage, we'll be able to investigate and therefore prosecute. So please stop everything you're doing now because we have a new constitution. And I'll just, I think, repeat also what Carla Firstman said. Let's ask the victims what they want. The victims may be wrong. The victims may not see the full picture, but the victims are saying this is a bird in hand. So part of what we have to do, especially when we're saying let not the ICC be the be-all and end-all, is give the victim something else to hold right now. But in several instances, I would say, the ICC has ended up, or the whole discourse around the ICC has ended up triggering attention on an issue and causing motion that would not otherwise have been there. Thanks.
Any panelists?
Am I going next? Yes. On the issue of Darfur, I think it's a very interesting and important point. I mean, leaving aside the wider debates about Darfur, in relation to what I was saying, I think there's an important point to note there, that the institutionalization of traditional justice is going back to an approach which was used rather effectively during the period of indirect colonial rule. It is a way of, if you like, using local mechanisms, choosing the ones that work and giving them external support and credibility. In the Sudan case, actually armed force to implement them. So, you know, I think it's worth just bearing in mind how this argument about colonialism works. Because often I hear, you know, international criminal justice is neo-colonial and traditional justice is, if you like, is the alternative. Actually, the institutionalization of traditional justice is exactly how colonial rule worked in the African context. And in relation to that last point from Human Rights Watch, I mean, I think a really important, if I think of what's happened in areas of Africa in which I've known well since the early 1980s, the impact of the International Criminal Court has been enormous. It's been enormous. You know, if I go to an Acholi village now, and, you know, speaking to people who I've known for a long time, they talk about justice and accountability in new ways. Now, whether that is the way we're talking about it in this room is another matter, but it has opened up an opportunity for discussion and debate. And if I had to pick upon the one thing that the criminal court has done in areas of northern Uganda in which I've worked, which has been barely recorded, it's improved the behaviour of the Ugandan army. The Ugandan army has been very nervous since the ICC prosecutors began work in northern Uganda, and you could see a dramatic change in 2004 in the behaviour of the Ugandan army. Now, how do you actually monitor this? How do you quantify it? I'm not sure. But I have absolutely no doubt that the International Criminal Court's involvement, its scrutiny of that area, has had all sorts of influences on local procedures that might be understood as rather beneficial.
The ICC prosecutor, in fact, said that the ICC would be working most effectively if there were no cases before the ICC, because it means national jurisdictions would be doing their job. That was said right at the beginning. And there is some value in that. The problem which I've tried to highlight, and it's by way of constructive criticism, because that's the only way I think that the court is going to progress and have a future, is to say that what is critical is when the ICC does intervene, it does it in a way that is transparent and fair. And the problem very often is, yes, it can create a basis for national initiatives, but very often the ICC has only taken one side of a particular conflict. So how does that then help the Congo when all of those people on the side of Kabila are just totally untouched? And I've seen this in Uganda as well. People say, well, it doesn't really assist us because Coney, fine, but what about other people in the country? And the moment that happens, it actually can make it more difficult for the national system then to create a fair and impartial process. Just briefly on Kenya, because that point was raised, I hope I made it clear that what the Kenyans were in fact saying was, look, we are investigating these cases, but we haven't come across the evidence that you, the prosecutor, say is there. And what we are wanting is you to work with us so we can have that evidence to have the trials here. So there's more than just an admissibility challenge. There was a request for assistance. And the court ignored that. And I think that was a failure, because it would have allowed the court right at the outset, while the whole process of looking at whether there was any evidence to confirm these charges was going on, to consider the value of that evidence. Is it evidence that is reliable? Can it be used in the Kenyan courts? And it could have dealt with all of those issues simultaneously. And just lastly, I think why this is all so important is because it's not only at the abstract level. I mean, quite practically now, as I mentioned in Libya, a situation's going on where the prosecutor's taken exactly the opposite view. He said, no, you've got a great system here, despite all the criticisms that are being raised about the problems with that new government and its judicial system. And no one is raising, no one who's in an important, significant position, no one is raising a problem. There doesn't seem to be a concern about whether or not trials go on there, and that the ICC doesn't deal with it. And it's just astonishing that at one moment everybody wanted everything to be done at the ICC, and now they're saying, oh, no, it's fine, that can all be done there. Why is that? And I think we've got a responsibility to answer that question.
Yeah, I mean, I'll also respond to Liz's question. I mean, my sense is that the ICC has some impact in Africa, but typically that impact is overstated. I mean, even, I guess, pushing back a little bit against Tim's comment about UPDF behaviour in Uganda, are they behaving better? I mean, this is a Ugandan army that fired on its own civilians during the election campaign last year. So, I mean, I'm not seeing a great fear within the Ugandan army about the threat of prosecution. My sense is the message that's been sent to the Ugandan government in recent years is, we're all about the LRA. Prosecutions are for rebels, and don't worry about what government actors do. There's absolutely no chance of government prosecutions in Uganda. And I think that message has been sent to the highest levels of the Ugandan government, and it spreads through the army. I don't think that there's any deterrent threat in that sense. Many human rights groups have also tried to claim that a message has been sent to African rebel leaders about the recruitment of child soldiers because of the Lubanga case, that this is also having a deterrent effect. But even in the last week, we see these reports about the fact that Ntaganda in Eastern Congo apparently recruited another 150 child soldiers just in the last month. So, I mean, we have to be serious here about how much deterrent effect we think the court is ultimately having. In terms of the improvements the reforms in the Ituri judiciary, I mean, this was a process that precedes the ICC. So I really don't think that the ICC has had that much of an impact on what's happening in the domestic courts in Ituri. The reform process, I think, has much more to do with the willpower of domestic judicial actors and the willingness of the European Union to put money into that process. That's a process that began in 2003, so it began 18 months before the ICC was a flicker in anyone's eye in Congo. And again, it comes back to this point that Lubanga, Katanga and Ngorjolo were being investigated by those domestic courts before the ICC got involved. So there is another world for these courts before the ICC started to get involved. In terms of Ntaganda, why is he being pursued
I'll have to give it, we're really running out of time.
Yep, sure.
I'll be brief. Let's end on a nice note. I think if the ICC's done something positive, maybe it's through its mistakes, it's managed to sort of raise some sort of international awareness. And I don't mean amongst people who are sitting in this room, but maybe at a more basic public level. Look at CONI 2012. Suddenly, here are, the youth of society involved in issues that, belong in international criminal justice. So maybe the ICC, at the moment, if it's doing anything good, maybe it's, I don't know, building some sort of common humanity, shared humanity, values that are maybe common across all nations, even if there are political problems with how it operates.
Yeah, thanks. I'm from Malawi, so and we have a very direct experience with the ICC right now. We are supposed to host the African Union Conference in July, and Bashir is supposed to attend the conference. The current president of Malawi was against hosting the conference, but now she says she will host the conference, and she's a very active human rights person, and she's against Bashir coming. But she, at the same time, respects what the AU says, which is that the host country has no right to decide who can come in or cannot come in. But more important, where the IC comes, the strength of IC, is that in this case, there's a $350 million of the Millennium Challenge Fund that Malawi has just qualified for, which has been withheld twice now for human rights violation. And the government's question, if Bashir comes, they will lose $350 million. And they have no way of stopping him from coming. And so anyway, the power of the ICC is not only in the fact that they prosecute people, but actually this international, it can be used as a tool by international, in this case very clear, it's a $350 million grant from the MCC in the US, and if he comes, Malawi may lose that. I think with our panel, we had a great panel, and I'm sorry for cutting into your lunchtime, but I think the panel says